This is Sean Keith with Keith Law Group. I want to talk to you about the next phase that you've been entered into, and that is the litigation phase. Look, from the very beginning of my practice, which has been more than 30 years ago, I said, and I may have told you, we're going to be reasonable. I'm always reasonable because if the insurance company is not reasonable, it makes it an easy decision to file a lawsuit against the other driver. And that's what's happened. We've reached a point in negotiations where we can't come to an agreement with the insurance company, so we're filing a lawsuit. So what happens now? Well, the first thing that happens is you're going to get a plaintiff fact sheet. You'll get that from our senior case manager. If you haven't met her yet, you will now, because she's in charge of all of our cases that are in litigation. And about 10%, 10 to 15% of our cases go into litigation, okay? So one of the first things you're gonna get is a plaintiff fact sheet. And I need you to fill that out, and I needed you to do it in the next couple of weeks. It's important. It's a lot of information, kind of like your intake back in the day when we first started your case, but it talks about who we're gonna call as witnesses, what your pre-existing injuries have been, what your employment's been. We do all of this ahead of time because we know that the insurance company's lawyers are going to ask you those questions as soon as the case is filed. So we get it prepared, and then hopefully we're not scrambling around when we have a small amount of time to answer them, and we already have it ready to go. I like to do everything in a very organized, efficient, and fast manner when we're responding. That sends a message to the insurance company's lawyer. We have our stuff, our ducks in a row. How long is this going to take? Well, it really depends on a number of different factors, but generally speaking, it depends a lot of times on the judge, his schedule or her schedule, and what kind of pace they want. If we're in federal court, it goes a lot quicker. You're probably going to get into court and done with court in a 12 to 15 month period. If it's state, it's probably a 18 to 2 year period. Sometimes it's quicker, sometimes it's longer. But that's what you're looking at, 1 to 2 years. Now, oftentimes I have cases where they are being unreasonable, the adjuster's being unreasonable. I file a lawsuit, first phone call, just happened recently. First phone call I got from the other attorney was, I don't know why they didn't pay you your limits on this. I don't know why they didn't settle this for all, but here's all the insurance money we have. Will you take it? I said, sure, of course, but you're gonna need to pay for my filing fee and the process server, and they did. But if that doesn't happen, and settlement can happen anywhere all the way up to the day before or at trial, I never act like we are gonna settle, because that's the first time you don't. When you act like you're going to, you never do. So we're going to be pushing hard, and we're going to be working on your case in litigation. If your case is in litigation, you need to be really in tune with our requests, because generally we're on a tight timeline. Other than that, you're going to give a deposition. That's just where we all get together, probably at my office. We sit down, and you basically tell the other lawyer your story and what happened and what your injuries were. I'll prepare you for that, or someone in my office will prepare you for that, and the preparation will be much, much longer, probably worse than the actual deposition. After that, we're going to call your friends and family and talk to them as witnesses. You're going to give us in that plaintiff fact sheet a list, and I want as many as I can get. And the closer they are to you, the worse. So if you have a next door neighbor you're not very close to, but notice that you quit mowing your lawn, had to hire it out, put them on the list. Tell them, hey, this is what I need from you. It's about 5 minutes. The best testimony I ever get in a case are 5 minutes from people who are acquaintances who can tell the jury, yeah, I knew him before, I always saw him mowing their own grass, doing their own yard work, lifting boxes at work, whatever it is, and now they don't. So we'll talk to the witnesses, They probably won't get their depositions taken, but we will need for them to come testify if it ever gets down to it. We'll find out when your trial date is, and probably 6 months down the road after we file. If you have any questions during litigation, don't hesitate to contact us. I will tell you, once your case hits litigation, you'll hear from us a lot less. It'll go in spurts. You'll hear from us a lot now, then you'll get your plaintiff fact sheet in, then you won't hear from us for a while, then you'll hear from us again when we get ready to do your deposition, and then after that you won't hear from us, and then we may get a settlement offer, and then you may hear from us, and as we get closer to trial, you'll definitely hear from us. So, any questions, contact us. I'm Sean Keith with Keith Law Group. You're in the litigation phase. Now let's go get it done.